Hello and welcome back to another episode of Pragmatic Optimists. I am State Senator Tiara Mack from Rhode Island, and today we are joined, me and Rachel Cohen, another attorney, are joined by another attorney who is in big law, navigating this current moment. We're excited to be joined by powerful voices who, in the words of Ketanji Brown Jackson over the weekend, are using their voice to dissent and to fight back. So Rachel, why don't you kick it off and introduce us to our special guest today?
Thanks so much, Tiara. And Ryan, I'm so happy to have you. We're joined today by Ryan Powers, who is a classmate of mine and until very recently was employed at another large corporate law firm, Davis Polk Wardwell. And he can correct me if I get that wrong because I am not always great at knowing the names that go in the law firms after the first one or two that we abbreviate down to. But I'm so proud of Ryan and thrilled that he's here today, though disappointed by the circumstances, which I'll let him tell you about. But as y'all know, the kind of state of the most powerful attorneys in the country is pretty abysmal. There's a number of giant corporate law firms that have made explicit quote unquote settlement deals of questionable validity, questionable legality with the Trump administration as the president tried to intimidate them. That's what brought me to Midas Touch and Legal AF originally. And now it brings Ryan as well. So Ryan, why don't you tell us just a little bit about your time in corporate law and what ultimately led to you parting ways. And we'll ask some follow-up questions and kind of give our audience a little bit more insight into what that industry looks like and how you can stand up.
Thank you, Rachel. I really appreciate it. And thank you both for having me. Excited to talk more about this, but unfortunate that these are the circumstances that led us all here. So my story really starts, I think, in March when the Trump administration, as I'm sure has been well covered, began issuing a series of executive orders that were targeting the legal profession. So security clearances were stripped from powerful attorneys. Firms were targeted by name, as you know, obviously, Rachel. And frankly, the lack of impartiality from the Trump administration and allowing the legal system to operate as it normally does is something that I found inexcusable. I ended up trying to navigate that to the best of my ability while being employed as a corporate lawyer. I started writing. I thought, as I stated in my op-ed, that if the law itself was becoming harder to trust and a little bit more political, that at least maybe it could be easier to understand for people who otherwise aren't lawyers, but maybe just want some insight into what's going on. So I started writing, and I covered topics like the Wisconsin Supreme Court election, a bill that was popping up in Montana and the implications for Montanans. I wrote about an upcoming Senate election in the state of Texas, but really from the perspective of someone who just wanted to share and disseminate information. I was never giving any sort of personal views or trying to convince anyone to vote a certain way or do anything other than just explain what was going on and then allow people to make their own decisions and figure out how they felt about the issues that I was presenting. This came to a head really in mid-May. I put out an article about threats to privacy and free speech that were happening primarily in Chicago because there are organizations like Palantir that mine data and collect it and have a previous history of working with powerful organizations like the federal government, and what that means for folks in Chicago and how to protect themselves and what they can do as citizens who may not necessarily even be lawyers, but are people who are concerned about the law, concerned about their own safety and their own rights. About 2-3 weeks later, the New York Times broke the story of Palantir and the Trump administration had actually been in collaboration for several months prior. About a day or two later, I ended up talking to one of my coworkers who informed me that the firm was unhappy that I had been writing articles. I had a meeting with my practice group leader, which is essentially my direct supervisor. And there was, unbeknownst to me at the time, a third participant who had been invited to the meeting. And that was a woman who was in charge of professional development, which is functionally HR. In that meeting, I was told that I had violated firm policy. And I wanted to read that to everyone here just so they understand what this policy is, because that was really the point of contention. It reads, lawyers at the firm must be sensitive to the fact that writings and/or public statements on certain legal, business, and other issues may directly or indirectly affect the interests of the firm's clients or the firm. Given this need for sensitivity, lawyers and staff who are considering whether to publish a book, paper, article, or other writing, or to participate in a public speaking event that may be relevant to the business interests of the firm, its clients, or its vendors, must first get public approval or get approval from their practice group coordinator or the senior leadership team, which is essentially just your direct reports. And why I found this so troubling was it was presented to me as though my violation was because I didn't ask for permission. However, months prior to that, I had initiated dialogue several times with the firm to understand what exactly could be published. I had emailed a few times, and every email that I got back was some degree of, let's talk about this in person. Let's meet in person. And I kept prying for answers and trying to get something in writing, and I never could. So frankly, it felt a little bit disingenuous to me, and I was ready to call them on it. So I kept writing. And the very next day, after this meeting, I wrote an article about threats to protest culture in Philadelphia and ways in which the federal government could effectively police and chill free speech in Philadelphia through protest, through similar initiatives to what Palantir and the Trump administration had been actively working on. And I sent it to firm leadership directly. And I said, this is my opinion. It is in my own words. All of this is completely outside of work. I think it's important. It is about folks' individual constitutional rights. And I think it needs to go out. They had an opportunity to review it. And I asked for an explanation in writing if it was rejected. I never got that explanation. I never got an answer to that email. What ended up happening was about 4 hours after I had sent that to firm leadership, I got a knock on my office door from two people I didn't recognize. One was clearly a security guard. They asked my name. They walked me down the hallway to a conference room. I was told that I was terminated, effective immediately. They walked me back to my office, gave me about 3 minutes to clean out my belongings, and then two security guards escorted me out of the building, and that was it.
Wow. Well, that is a story that is all too often, Rachel. I know you have also experienced your own removal from a big law firm, and as someone who has
I quit just to, I got ahead of them.
Yes, but as someone who's only worked inside of a big law firm, not as an attorney, I want to go back to your op-ed, and you have some pretty strong words about the state of big law. You use words like corrosive and corrupt. I want to learn a little bit more about what is the role of big law in upholding our current democracy, and how can big law, or what steps do you think big law can take to reverse some of the erosion of our core principles like free speech?
Right. Thank you for the question. So fundamentally, these firms have a lot of institutional and structural power that I talk about in my op-ed. They control policy, they influence the state of global affairs, and they are dealing with some of the most powerful corporate, business, political leaders in the world. So because of that, there is a lot of ability for big law to do something, and frankly, to do anything more than it already has. I don't think what happened at my firm was a one-off, and that's why I feel inclined to talk about it, is if this is happening at one firm and fundamentally you have all this power concentrated and they are essentially muzzling employees from speaking openly about the law, trying to teach people, trying to connect with non-lawyers, I'm sure it's happening elsewhere, and I think it's endemic.
Yeah. And another follow-up question before I know you want to get into some of the more nitty-gritty details, Rachel, just to be clear, who holds big law accountable in this system, and who is big law accountable to? They work with large corporations with multi-billion-dollar budgets, and the industry itself is a multi-billion-dollar industry. So who is big law accountable to, and who holds big law accountable? Just so people can really understand, because they build policy, because they shape markets, what is at stake if big law cannot be reined in?
So this is the problem, is there's actually not very good oversight of big law. There aren't institutions that are responsible for really policing what happens behind closed doors in big law and finding out what goes into the decision-making processes that contribute to whatever sort of outcomes occur as part of big law. And I think that's a real problem. I think few people in very powerful rooms are making decisions not on behalf of lawyers at firms, but on behalf of everyone else too. I bet most Americans cannot name a single one of these big law firms by name. I couldn't either before I went to law school, not a single one. And everyone knows JP Morgan. Lots of people know McKinsey, but certain powerful firms operate in the shadows because it's just a game to move money around. It's not the practice of law at all. It's the practice of avoiding liability and maximizing the bottom line, no matter the cost, even if that is the law itself.
I think that's such a good metric also for kind of how suspicious I am of an industry or an organization, honestly, is how wealthy and elitely educated I had to be before I learned who they were. And I'm sure that there are some that I am still unfamiliar with, right? But kind of to your point about McKinsey, I remember getting to Harvard and having to kind of do some research on what these consulting firms were. I had not heard of a large number of them. And sometimes when I say that, I feel like it sounds insane. Like I went to Ohio State and I did well there. And then I went to teach through Teach for America. I was already in these very kind of feeder spaces. But things like Skadden, both of my parents are government attorneys. And when I got hired at Skadden, my dad thought the name was SCAD and ARPS. I think it's just such an accurate and kind of valid point about the importance of speaking about things, particularly when you have insight into those spaces. I'm curious if they gave you any specific reasoning related to the articles that made them very sensitive. I've noticed that you've pointed to your article about Palantir, and I certainly have my own suspicions about what may have motivated the firm to start paying attention after that article. And I'm curious if they align. So I'd like to hear yours first. What were their sensitivities?
Yeah, it's hard for me to speculate. I was given very little information, and I think that's the real heart of the problem, is when there are ambiguous policies that exist and the enforcement is just as ambiguous, it becomes really hard to get any clear answers from organizations that hold the disproportionate amount of power. So I could certainly hypothesize. I think that the facts in some ways do speak for themselves, but I wouldn't want to put words in their mouth to suggest why exactly I think they had a problem with it. I do think it is interesting, though, that we have an ongoing deal with Trump media in the crypto world, and that got almost no publicity. There is a Bloomberg article that I linked to in my op-ed detailing the deal. But classically, I would say Davis Polk has a degree of pride over many of the deals that we run, right? And there's some degree of promotion somewhere along the line. I do not think that this is something that was promoted at all.
I think it's really, that's a compelling point and something that I would just point our viewers to if they're ever curious. It's really hard to tell who represents which companies. For example, GEO Group, this private prison company that's in the news all the time right now, is represented because, sorry, I should be clear about why. That's in the news all the time right now for assisting the administration in disappearing people into privately held immigration facilities. GEO Group is a publicly traded company. Palantir, I actually don't know if it's publicly traded. If it is, all of these organizations, you can go and look at their recent kind of credit agreements and large, it's called a material agreement. And so when publicly traded companies enter into these things, they have to file them on the SEC's website. And buried in there, you can sometimes see which law firm is representing those people or that organization. But short of that, if the firm chooses not to put it on their website, it's pretty challenging to dig up who exactly is representing who. And so when firms recognize that kind of the work that they're doing is perhaps a little bit more distasteful, and particularly when it's being done for mercurial billionaires like Peter Thiel, like Elon Musk, which I offer as an example because, and this was widely reported on, and I didn't work on it, so I can say it, my own kind of big law alma mater, Skadden Arps, represented Elon Musk in the Twitter acquisition. And I remember when I went there thinking to myself, I had accepted my job before they had taken on that representation, and really registering how much it limited my ability to critique Elon Musk in public without putting my job at risk. Were you, when you started writing, were you aware of kind of the risks that you were taking on to your career? It sounds like you'd been trying to get answers about what you could publish prior.
To some degree, I think. I mean, what's so insidious about this policy is because there's the phrasing of other issues in terms of what they can control and influence. There's really wide jurisdiction over anything. And so because of that, I have no idea what is acceptable to write about or not within the boundaries of, if you're publishing something that is offensive to the firm's interests related to law, policy, or other issues. Is that a chocolate chip cookie recipe? Is that a political critique? I mean, there's certainly gradations of inflammation, but I think when you are publishing something that is meant to purely articulate and explain the law without any clear political opinions infused in, no, I didn't think this was something that should be objectionable.
And I think particularly on issues that are so complex, like the ones that you've outlined, and also so important, it's unbelievably disappointing, despite the fact that as someone else with experience in the industry, it's ultimately not super surprising to me that any firm could say that that is adverse to their interests. What exactly do they think their interests are? And I'm curious, Tiara, I'd actually love to go to you because I'm not sure that we've spoken about on the channel the fact that you did some diversity work at a large corporate law firm. All of us have experience in this industry, and I'd be curious about your perspective as someone that worked there but was not an attorney into kind of what was prioritized, especially when your whole job was focused on hopefully doing diversity and inclusion efforts.
Yeah, I was also at a big law firm right before the Trump administration, and then within, I believe, around the same timeline as you, Ryan. I was completely removed off of all diversity, equity, inclusion hiring. The firm completely dismantled the team. And then for the last month of my work, I would show up to my desk every day and have nothing to work on because they were leading the internal investigation to hand over years worth of diversity, equity, inclusion data to the administration before they joined the league of firms that now have given the Trump administration almost $1 billion in pro bono legal services. And so I've seen it from the staff side, where the priorities no longer became this commitment to diversifying this elite elite law community, where there are very often not many people who look like me, not many people who come from a low income background, not many people who didn't go into the feeder system of Ivy League undergrad or top tier school into an elite law school. One of the top 14 law schools in the country is pretty much where my entire firm sourced from. So if you didn't go to a school with a big name or a program that already had an established pipeline into that firm, it was almost impossible to get your name in there unless you were connected in some other ways. And so I also like to think of these as the institutions. Big law is an institution. We also saw some of the degradation of Ivy League institutions in this current administration, and how many have also caved to the demands. Just recently, Penn has decided not to allow trans athletes, even though they are less than 1% of the population and even fewer in NCAA sports. I'm curious to know a little bit more about what truly is the risk if big law continues to follow down this path, and bringing up more courageous voices like yours, Rachel, for speaking out and leaving your firm, and yours, Ryan, for continuing to speak out when the rules didn't make sense. What will be required of more courageous leaders to step up and say that these institutions are really large, and if they do fail, this is a pivotal moment where our country could also see a cascade of future failures in other systems that we deem too big to fail?
I think we need real accountability from the people at the top. I think that's what it is fundamentally, right? My argument is not anything against anyone who works in big law other than leadership, other than the individuals who are driving the ship. I understand very clearly that there are certain reasons that people go into big law. I write about it in my op-ed. I understand that very well, and I think that a lot of it is very justified. What I can't forgive, though, is firm leadership and the active choices that they make. And by that, I mean, I think there's a high degree of hypocrisy when fundamentally there are 3, 4, 5 different web pages on Davis Polk's website that tout our commitment to pro bono, to social responsibility, to defending, values that we look at as integral to our legal system. And in the same breath, I heard a story from a colleague 2-3 weeks ago where someone on a deal they were working on at Davis Polk had died. And instead of acknowledging it at all, the firm just removed the person from the calendar invite and continued on with the meeting. And I just think that it's really disingenuous to suggest that those two things can work in tandem and silencing speech can work in tandem. It's disrespectful to our clients. It's disrespectful to the law students who don't know any better and otherwise apply to these firms. And it's disrespectful to the legal profession, quite honestly, because we are an industry of truth and transparency above all, right? It's a little bit corny, but it's true. We swear in an oath. We stand in front of a judge. We get up there and we do it. We take a professional responsibility exam. This is an industry that is supposed to support the law. And nevertheless, here we are doing things like this.
And I think, too, it's such a risk-averse industry, right? And that's for a number of reasons. It draws people, especially if you're able to get into one of the schools that feeds directly to one of these firms, get an offer at a firm that you like. People, it's a clear pathway to being quite wealthy in the United States, and people pursue that for a variety of reasons, both people who are from lower income backgrounds and people who are not. And so I think that people already self-select onto this path because they are not big swing for the fences risk takers. And then we go through a series of legal education, and this is something that Ryan and I have spoken about at length, because we actually had a class together back at Harvard, and we go into this system of legal education that deprioritizes any type of consideration of justice, any type of introduction of lived experience a lot of the time. And we're told that we need to debate all of these things in a vacuum. And so then it starts to feel like a really big risk to stand up for things that are right just because they are right, because you know it in your gut, as opposed to waiting and gathering all of the information and then acting way down the line. Something that I've been trying to communicate to people, not just attorneys, but across the board, is that it's not going to get any easier with more data collection. Like, we have enough data to know that what is happening in the United States is early stage authoritarianism, and that we need to act in a way to dismantle that and to slow it and to run the clock as much as possible so that we can make it to the next election, hopefully before too many different protections are eroded. And one of the ways that you do that is by educating people, particularly if you're someone that speaks with authority like Ryan is. I think that one of the real difficulties here is that a lot of our institutions in the United States are really flawed, and big law is certainly one of them. It's not a sympathetic victim to have big law firms or even big law attorneys, though I think, Ryan, you're very sympathetic and I'm very sympathetic and everybody else, but there's real frustration at the industry itself. And so because of that, I do think that sometimes we don't think about the next step after, where even if we have, and I certainly do, we have these deep underlying issues with the industry. I think of it in terms of even the election. I have huge issues with different ways that certain leadership within the Democratic Party is making decisions right now. We do not have infrastructure to protect vulnerable people if we just let those systems not only collapse, but actively aid in the kind of authoritarianism that is taking place under the far right. And so it's this needle to thread where it's really not a pro-institutionalist argument whatsoever. And I always am kind of like, but then am I shitting too hard on the institutions? Because I do think that all of those things need to be said. But at the end of the day, we're playing the game that's in front of us. And it would take a lot of people to agree to just like stop playing it that haven't done that yet. I don't know, Tiara, especially from the elected side too.
Yeah, Rachel, I think what you really are getting at here is that there's so little faith in our institutions right now. We also live in a hyper polarized society right now. Polarization on both spectrums at an all-time high. Mis and disinformation is permeating certain sectors of American society. Lots of folks don't really know what goes in big law, as highlighted by some of this conversation, and it's accountable to no one. It is a multi-billion-dollar industry that many people can't even name some of the biggest actors in these spaces. And so when you have a loss of faith in these institutions, how do we win faith back in, whether it is, as me, working in the state legislature, where so many people don't even know who their state legislators are, and often get them confused with the federal level, when many folks can't identify who are the biggest people deciding whether or not companies merge or how they interact with our communities, when so many people don't realize that the feeder for becoming Justice Roberts is through this big law pathway, or even someone as prominent as you mentioned in your op-ed as well, Ryan, Michelle Obama. How do we get back faith in these institutions, and how do we highlight how just important they are for people to not only pay attention to when our democracy is in crisis, but also when we have a healthy and strong democracy?
Yeah, I think it comes down to education as much as we can, and trying to really get out the message that our institutions aren't going to be there if we don't fight for them. There's not going to be a democracy to return to if we continue to let powerful actors control the direction of the country without any sort of meaningful check or balance. It's just not going to happen. So I think fundamentally, we need to really work on getting this message out there and doing things like this and questioning why rules exist. I think as lawyers, we are taught that just because something is the way it is, then it is the way it is. And that's not how the law should be. Fundamentally, there are things that have been legal in American history, in global international history, that have been legal, but have been absolutely immoral over the course of human history, right? And I think fundamentally, questioning policies is really important, right? I think you both hit on some really good questions about what was the firm's motivations? Where are their interests? Where is this all coming from? How can I understand it better? And I think that's very well taken. We should be asking these questions. That's the point, is I think people are so used to not asking these questions, maybe just because we don't know where to start, maybe because we feel powerless. But if we start asking the questions that matter, and we start going to authority and questioning why policies are the way they are, I think that's a great first step.
And I think too, I think this lets me close the loop really nicely. I want to note that you did ask the questions internally. And I think that's one of the things that sometimes makes people feel a little bit demoralized, is that they'll try basic kind of organizing or question asking and hit a wall. And I think that in these very insular industries in particular, there's a real problem where people hit a wall and then it feels very risky to take it any further. And I think that that's something that, at least on this kind of area of big law work, keeps me very optimistic and hopeful, is that I think that a number of associates resigning or being unwilling to change things and getting fired from these industries, and then really putting the pressure on the firms to answer questions publicly, I recognize that they still haven't, right? And you're probably going to be the introduction to Davis Polk for most of the popular consciousness. We're getting, a couple at a time. It really is the whole industry. I hate to say it, but some certainly less than others. I think that kind of asking those questions or refusing to back down is a key piece of doing that educational work and keeping media focused. And I am curious to close, what made you willing to continue down that path as opposed to hitting the roadblock, and what is keeping you hopeful going forward?
Yeah, thanks for the question, Rachel. I think that fundamentally, I felt a deep responsibility to speak out when I started feeling internally uncomfortable. And I think that's something that people have to trust their gut on. When something feels wrong and you don't understand it, and you try to get answers and you still can't understand it, I think in some ways that's a call to action. And I feel like not only did I need to speak out, but I needed to do so now and loudly, or else this will keep happening and get worse. I want to show people that actually, individuals can do a lot. And just because you're one person, a cog in a machine that is more powerful than you can ever even fathom, you can still change something. or get people talking or start dialogue. So that's very important to me. And I think my source of hope comes from that. I know there's going to be at least one or two people who see this who don't agree with me, and that's fine. But I think there's also going to be one or two people who see this and they're going to think, okay, I should press a little bit more, or I should ask another question. And I'm really hopeful about that.
No, I am as well. And I think that we've certainly seen how far it goes to demystify a complex industry like this one by having compelling people talking about it and educating. And so hopefully more than one or two people, and you all can help us make sure that that's the case by sharing this video, liking and subscribing to Legal AF on Midas. Myself and Tiara have personal social media at Cohen.489 and at Mack District 6. We'll make sure that Ryan's op-ed is linked in the comments. I have read it and it is really exceptional. And you can continue following along with him. Where, Ryan?
I'm on Ryan Will Powers anywhere that you have socials.
Fantastic. So we'll make sure that's up on the screen as well and hope to continue these conversations. But thank you so much for the risks and the kind of integrity that you've shown here. I think that it's so important and really looking forward to seeing what you continue to do with it.
Thank you both.
Yes, thank you so much for joining us, Ryan, and for sharing your optimism and your voice. It is powerful and so necessary.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.